All right, welcome to the final lecture of 2.5 and the dual court system. By now, we've covered the basics of the court, specifically the Supreme Court and the Courts of Appeals. And then today, we're going to review these as well as talk about procedures and the intricacies of the dual court system. So, when we think about how our founding fathers established the federal courts in Article 3, okay, we have to remember that 13 states already had their own courts and were hearing their own cases. So the dual court system allows for those courts to work independently as well as overlap in order to provide a solid legal system. So on the left-hand side of the screen, we see the federal courts, which has the U.S. Supreme Court, which reviews the decisions of the federal and state trial and appellate courts. We have the U.S. Courts of Appeals, which is 13 appellate circuits, and they review the decisions of the federal district courts. And then lastly, we have the U.S. district courts. There are 94 judicial districts. The trial courts hear civil and criminal cases. And they also include specialized courts, such as bankruptcy and international trade. On the right-hand side of the screen, we see the North Carolina court structure. We see that our North Carolina Supreme Court only has 7 justices. We also see that our Court of Appeals has 15 judges. Our Superior Court has 109 judges. Our District Court has 256 judges. And then we have 724 magistrates. So the magistrates, the District Court, and the Superior Court are all trial courts. So let's talk about types of jurisdiction. And remember, jurisdiction is the authority to hear and decide on a case. So original jurisdiction, that means the court is the first court to hear that specific case. Appellate jurisdiction is when a case is appealed from a lower court, so it has already been heard by a court before it gets to the appellate court. Exclusive jurisdiction, this means that only federal courts can hear and decide these cases. So federal courts, remember, those are our district courts, our U.S. district courts, our U.S. courts of appeals, and the Supreme Court of the United States. And then our last type of jurisdiction is concurrent jurisdiction. That means that both federal and state courts have jurisdiction and can hear and decide a case. So those are our 4 types of jurisdiction. All right, so if you would like to pause this recording here and navigate to slide 23 of your Pocket Constitution, that would be wise. As slide 23 talks about the dual court system, specifically jurisdiction, and the hierarchy of the dual courts, with the Supreme Court on top, followed by the Courts of Appeals, and then at the very bottom, we have the district courts. So our federal court system. So as I said, the hierarchy, we have this Supreme Court at the very top. We have appellate courts and then trial courts. And that is our federal court hierarchy. So let's first start with talking about the Supreme Court. So remember, the Supreme Court has original jurisdiction over certain cases. And that jurisdiction is when there are conflicts between states. It has appellate jurisdiction, which also means it can choose which cases it hears. And remember, it established the power of judicial review for itself through the case Marbury v. Madison in 1803. And remember, judicial review means that it has the power to review any local, state, or federal issue to check for its constitutionality. So it's going to check for whether or not something is constitutional. And under this power, the Supreme Court has the ability to overturn the law or action if it is deemed to be unconstitutional. So judicial review, again, is what allowed the Supreme Court or the judicial branch to check the legislative and the executive branches. In the U.S. Supreme Court, the court itself typically selects cases that involve major constitutional or legal questions. So think about Brown v. Board of Education, abortion rights, rights after 9/11, so like terrorism issues, things like that. So the Supreme Court selects cases that are important to society and to the way we live our everyday lives. Now, in order to get your case before the Supreme Court, you're going to have to petition the Supreme Court with a writ of certiorari. Okay, that is a petition for the Supreme Court to hear your case. And if it is accepted, it will be placed on the docket. So remember back to our Supreme Court simulation where 4 judges or justices had to accept the case in order for it to be placed on the docket. The Supreme Court uses that rule for real, and it is called the Rule of 4. So 4 justices have to always agree to hear a case before it is placed on the docket. And the docket is simply the court's schedule. So when we're talking about getting a Supreme Court or a case before the Supreme Court, this happens in several steps. Step 1, the parties have to write briefs. Okay, these are written arguments. They have to be 50 pages or less. And there are a lot of other requirements that goes into what font, what type of paper it is printed on, what color paper it is printed on, where the staples should be, all kinds of things like that. So the briefs are written arguments, and this is where the lawyers for each side kind of outline their arguments and allow the court to see why this case is important and why it should be heard. Step 2, we have the oral arguments. The oral arguments are 30 minutes or less for both parties. The petitioner always goes first. And remember, the petitioner is the person who is bringing the case before the court. And during these oral arguments, both parties must respond to questions from the justices. With step 3, we have the justices holding their own conference. And in these conferences, the justices are discussing the case, and they are voting on the outcome of the case. For step 4, we have the opinion or the decision. And the opinion requires that there are 5 or more justices agreeing to the majority outcome or the majority decision. And justices are going to write or sign on with one of the following types of opinions. So the first is the majority opinion, okay, or a concurring opinion. So a concurring opinion means that a justice agrees with the outcome of the majority opinion, but not how they got there, not the reasoning. Or the justices can sign on to a minority opinion or a dissenting opinion. So the dissenting opinion, that means that the justice agrees with the outcome of the minority opinion, but not how they got there. Okay, so the major differences between the majority opinion and the minority opinion is that the majority is the winning decision, and then the concurring opinion is saying that a justice agrees with the outcome of the majority opinion, but not how they got there. So, quick check. What are the 4 steps of the Supreme Court case? Remember, we have the briefs, which are written arguments and under 50 pages. We have oral arguments, which are 30 minutes or less, and the petitioner always goes first. And then everyone has to respond to questions from each of the justices, though Justice Clarence Thomas hasn't spoken in several years, so they know not to be ready for questions from him. Our third step of a Supreme Court case is the conference. All right, this is where the justices discuss the case and they vote. And then we have lastly the writing of opinions, where we have the decision. So again, other federal courts, we have the U.S. Court of Appeals. Here, the U.S. Court of Appeals only has appellate jurisdiction, which means they only review lower court decisions to see if proper due process was followed. Remember, the U.S. Court of Appeals, these are not trial courts, and only 3 judges sit on the Court of Appeals, or each of the districts, and they review cases and listen to the arguments. So they sit in panels of 3 judges. And the U.S. Court of Appeals judges, they can hand down 3 kinds of opinions. So they can vote to uphold. Okay, they can uphold the decision of the lower court. They can reverse or overturn the decision of the lower court, or they can remand the case and send it back to the lower court to be tried again. If the U.S. Court of Appeals, if they remand a case, okay, and they send it back, that means there was a procedural issue. Okay, so maybe there was an issue with letting certain kinds of evidence in. So think back to that case, Mapp v. Ohio, that we talked about a few days ago. So if, for example, the appeals judges decided that evidence was illegally obtained, they could send that back for a procedural issue. And it is important to remember that even if the appellate court rules to uphold, reverse, or remand, the decision can still be appealed to the United States Supreme Court. But what about trial courts or district courts? So trial courts, these are where most of the action happens. Okay, these are where criminal and civil cases are held. There are 94 district courts across the country. And district judges try a case, okay? Then the jury delivers the verdict. So the district courts, okay, they hear federal crimes, not state crimes. They hear federal crimes. Now we have the kind of other dual side of our court system. So we have the federal court system, which we just talked about, and now we have the state system. Specifically, we're going to talk about North Carolina courts. So at the very tippy top of this hierarchy of courts in North Carolina, we have the North Carolina Supreme Court. Under that, just like in the federal system, we have the North Carolina Court of Appeals. And then beneath that, we have the superior courts and district courts, and both of those are trial courts. So if we want to talk about the North Carolina Supreme Court, okay, just like the United States Supreme Court, they review cases of lower North Carolina courts, and they interpret the North Carolina Constitution. So think back to the Supremacy Clause of the U.S. Constitution and how the Supreme Court kind of decides what the law is, what the U.S. law is. Well, the North Carolina court does the same thing for North Carolina laws and the North Carolina Constitution. So currently on the North Carolina Supreme Court, there are 4 men and 3 women, so nearly evenly divided. So the North Carolina Supreme Court, they have both appellate and original jurisdiction. Okay, they have 1 Chief Justice and 6 associate judges. And they are elected by the people of North Carolina during our election cycles. So that's different from the U.S. Supreme Court because they are appointed, right, by the president, and the Senate confirms them. But in the North Carolina Supreme Court, they are elected by the people. Next, we have the North Carolina Courts of Appeals, and they hear cases appealed from the state's trial courts. The North Carolina Courts of Appeals have appellate jurisdiction, and they determine whether a decision should be overturned or upheld. There are no questions of fact, so that means we're not looking at evidence here, okay? And then we have our North Carolina trial courts. So we have the district courts and the superior courts. The district courts handles civil cases less than $10,000, misdemeanors, And the judges hear cases and decide the verdict. So the judges hear both things. There are no juries in the district courts. And this is called a bench trial. So when the judge is the judge and the jury, we call that a bench trial. We also have superior courts, and they handle civil cases that are more than $10,000. They also hear felonies and may involve jury trials as well as bench trials. So I want you to think about this. How does the dual court system utilized in the United States exemplify the principle of federalism? All right, so think about federalism. Think about what we know about federalism. Think about why it is important and why we might see federalism illustrated in our court system. So think about that, and I will ask you about that tomorrow.